Hello, my name is Courtney Pullman, and I'm a licensed marriage and family therapist practicing out of Wisconsin. Today, we're going to be talking about one of the most, for me, and sounds like from some of my colleagues, the most nerve-wracking experience ever is helping clients go through divorce, and especially with like the risk of being subpoenaed and asked to be an expert in child custody and mental health evaluations and those types of things. It can get really ugly with or without a therapist involved. And it's one of the more common reasons why therapists are called into court. So it's really important to go over so that people, new therapists especially, have an idea of what to expect and tips for getting subpoenaed. So first, we're going to be talking about the general divorce process. I practice out of Wisconsin, so some of the details might be more fitting for Wisconsin, but we're definitely going to be talking about uh, national law and national ethic concerns for marriage and family therapists across the nation. The next bit will be child custody, talking about what it is, why it's important, um, what how much court are really involved in that. Um, and then next will be considerations for evaluating child custody arrangements or the mental health of the caregiver. And that's where it really, as a therapist, it gets really difficult sometimes because divorcing parents or arranging child custody of parents who maybe never were married, they can get pretty nasty. So what is a therapist's job in that regard, and how do you uphold what you're supposed to be as a therapist, and what's your job as a therapist when attorneys and other parents can be really pushy about what they want. So next we'll be going over the AMFT Code of Ethics and what to consider there, and then tips for releasing information when you are subpoenaed. All right. So first, let's go over what happens with a divorce. Um, First, a spouse has to file a petition to begin the divorce process. Even if one spouse agrees to get divorced and the other one doesn't, which can be a familiar problem for some therapists, um, a divorce can still occur. That person can still be served papers. Even if both spouses agree that they need to get divorced, somebody has to petition for the divorce. In Wisconsin, like many other states across the nation, is a no fault state, and that means that you don't need to prove that you've been wronged in a divorce. There doesn't need to be abandonment or an affair or anything like that. In Wisconsin, you can get divorced based on irreconcilable differences or really anything. It's kind of at your own discretion. So after the divorce has been petitioned, there might be a temporary order. Typically, that's what occurs, and that's will be kind of an initial hearing that will be like, hey, this is what's going to happen through the course of the divorce, because the divorce process, depending on how well the spouses can agree or disagree, um, they need to know in the meantime what's going to happen. So temporary orders might discuss like child support, placement and custody of the children, who's going to live in the home. Um, and then the nice thing about a temporary order is that it's usually granted within a few days and it remains in effect till the final court hearing. Um, so and yeah, that sets the groundwork for the divorce. What happens in the temporary order doesn't necessarily mean that that's how the whole divorce is going to flesh out, but it's important for clients to get that temporary order in place so that they can understand what's going to happen through the process. Next, they need to have the process. The process begins, then there's a response, kind of, all right, so what do you want? What do I want? Kind of give and take type thing, petition and response. And then there's the negotiation. If the parties don't agree on all issues, they need to try to negotiate their differences. The courts at that time might schedule mediation. Um, Especially with child custody. In Wisconsin, the court does not want to get super involved if they don't have to. They would rather have it go to a mediator and have the mediator kind of help the parents agree on what's best for the child and then present the court with that agreement versus a guardian ad litem, and other like lawyer stuff involved with that. Um, and then there's there's the divorce trial. If there's not agreements, a lot of the times it can be resolved within a court commissioner. You have your paperwork, you've already agreed on this, or your attorneys have already agreed on it, and the divorce can be done fairly quickly. If not, it goes in front of a judge and it's decided at trial. Both parties will give testimony, sometimes multiple testimonies. Um, and then finally, there will be the order of dissolution, which ends the marriage, spells out how the property and debts are to be divided, custody, support, any other issues. When the parties negotiate their own resolution, they can draft their own order of dissolution, submit it to the court. If the court approves it, the court approves it, and then it is over. Um,